As the court is aware, we've raised 3 issues. Oh, by the way, I would like to reserve 3 minutes for rebuttal.
Once that yellow light goes on, that means you have
Okay.
3 minutes left.
Thank you. We've raised 3 issues, all are evidentiary issues. The first one goes to the issue of liability. The other 2 go to the issue of comparative negligence. I'm going to start with the first. I think that the standard of review on our first issue, which is the accident report privilege, should be de novo. There seems to be a dispute on that issue. The appellee believes that that issue should be reviewed under an abuse of discretion, which is obviously the general standard for evidentiary issues. The Sotolaro case in the 2nd District said that this issue is reviewed de novo, and I think they're right. When you have essentially undisputed facts regarding who was the witness, who was the driver, etc., like here, I think the parameters of the accident report privilege should be determined as a matter of law. And we believe the court erred in keeping out testimony from the investigating police officer, the police officer who investigated this motorcycle accident, regarding what a witness told him. That's Nicole Armstrong. And she had an accident. It was related to this accident because she was avoiding debris from the motorcycle accident when she hit another car.
There's no question on this record that Ms. Armstrong was not at risk for being charged with the initial accident with the motorcycles, right?
No question at all.
No question, right.
I don't think there's any. The 2 issues that the courts have looked at is the 5th Amendment privilege and whether the person giving this statement was compelled to do so under the statute itself. And that involves drivers, owners, I think there's one other category, but the case law is rampant that it does not apply to witnesses. So the argument here, which was accepted by the trial judge, was that, well, she wasn't just a witness because she had her own accident and they were related. Appellee is taking that position on appeal. Respectfully, I think it's just wrong. I mean, if you want to look at her proffered testimony, it's at pages 45 to 50 of the supplemental record. She was asked about when she spoke with this police officer. All she told him was about what she saw in the accident. She didn't talk to him about her accident. And the police officer also made that clear. He wasn't investigating her accident. There were 2 separate accident reports, 2 separate police officers, etc. Yes, were they related? Yes, but they were not. It was not one accident. And as Judge Gross just indicated, she wasn't at risk under the 5th Amendment. And she didn't. There's no testimony that she thought she was.
But when you say that, though, about the separate accidents,
Yes.
I mean, it seems that the record reflects that at this when this event occurred at 11:18 p.m., that there was an accident. I mean, it was obviously separate accidents. I suppose, if you really break it down meticulously. But the fact is, when Miss Armstrong was asked and questioned, she was asked about the accident, not accident 1A, and then we're going to turn to accident 1B. It was about the accident. So
Right, but I think if you look at her testimony, I think she believes she was just being asked about the motorcycle accident because that's all she testified to. Now, were they related? Yes, because she was avoiding the debris. But there was no contact. She didn't contact any of the debris. Nobody from the first accident contacted her. Her accident was basically with her car and another car that was unrelated. So, if you look at her testimony, I think it's pretty clear she thought she was talking to the officer about the motorcycle accident. That's all he asked her about. And under these circumstances, this is a very important witness for the defense and I went into great detail in the initial brief about the trial testimony. I suppose the court might have thought I was going to be asking for a weight of the evidence issue, but I did that because I wanted to make it clear how important Nicole Armstrong's statement to the police was. The only 2 witnesses who testified that there was any contact between my client's Camaro and either of the motorcycles was Mr. Regal, who was one of the plaintiffs, and an eyewitness, Ms. Morales, who said Vincent, one of the other plaintiffs, told her that there was contact. All of the other witnesses are all over the place. We had
Wasn't Miss Armstrong,
yes.
she was inconsistent because she originally gave a statement to the police officer that got into the report, and then in her deposition said she didn't see it.
She was completely inconsistent, absolutely, Your Honor. And she was asked again and again during her deposition, are you sure you're not recalling it? And she said, I don't think I said that to him. You know, I mean, honestly, that's what she said. But those kinds of inconsistencies, I think, are for the jury. The Sotelaro case directly, and that's a second district case, directly said that this kind of evidence from an accident report from the police officer can be used for impeachment.
So would it have come in as a prior inconsistent statement, or would it have come in as some substantive evidence?
You know, I think it would have depended on the order of proof. It didn't come in, so, you know, we didn't. But if her deposition had already come in wherein she said, I didn't see the accident, then it would probably have been used for impeachment. Alternatively, we might have brought it in for positive evidence.
Well,
Either way.
You would rather have had it in the latter, I would think, because she testified to your client's benefit.
Right. Either way, the jury would have heard it. And the jury would have heard it, you know, these inconsistencies, which in the course of this trial, where the evidence was so all over the place, we believe would have made a substantial impact on the liability issue. And we don't have the burden, of course, under the Special versus Bowe case to show that it was harmful, but I think there's always a psychological effort by the appellant to show that it was harmful, and I think that we've done so. So as a matter of law, we believe that this was an erroneous ruling and justifies a new trial. Our second issue pertains to alcohol. I agree that that is reviewed under an abuse of discretion standard, but based on the case law and the amount of evidence that the defense proffered, we believe that this was clearly an abuse of discretion. And I want to
What about the fact that the driver that had the passenger ended up testing with no alcohol content at 4 a.m. in the morning?
I'm glad you asked that, because I was just about to tell you about a case that was cited in my brief, but not for this proposition, which I discovered had actually addressed that proposition when I was reviewing for the oral argument. The case was cited for the accident report privilege. It's the State versus Nordstrom case, Supreme Court of Florida, at 613 Southern 2nd, 437. That was a case in which the driver was given his Miranda rights, and after that he told the police some inculpatory or culpatory statements about the accident, and that was the main issue in the case. The Supreme Court said, you know, you don't have to give him a separate warning. He was told he didn't have to speak, so the Fifth Amendment is not of concern here because he was Mirandized. So we're going to let this in. But if you look at Head Note 4 of the opinion, it says that even though this individual had blood alcohol content of 0 by the time of testing, evidence that he'd been drinking that evening was admissible.
And didn't they admit that I think the girl had had 1 drink and the guy had had 2 drinks several hours before?
There was certainly, our evidence was in 3 categories. Number 1, admissions that they were drinking. Number 2, other evidence that they'd been drinking. And number 3, an expert witness.
But the second motorcycle driver not only had been drinking, but apparently smelled of alcohol from one of the witnesses that was there to help.
Yeah, I would put in the second category of our proffered evidence. There was an individual who said that one of the motorcycle drivers smelled of alcohol. Miss Morales, who was the witness who went to the aid of Miss Vincent, said that she smelled of alcohol, and she said that Miss Vincent admitted that they'd all been drinking.
Was any of that admitted?
No, none of the alcohol stuff was admitted.
So not even Morales' statement?
No. Nothing pertaining to alcohol was all kept out. The jury had no inkling that there had been any alcohol involved in this incident.
Doesn't there need to be, though, as your opponent suggests, some sort of causation link here before that kind of evidence comes in?
Well, no. The answer is clearly no. That's for the jury. There are several cases that we cited where the only evidence that came in, and the court said this was fine and admissible, was statements by third parties that someone said he was drinking or he smelled of alcohol. It's for the jury to determine whether these individuals' impairment from the alcohol had an effect on the accident. And we had an expert witness who was not allowed to testify because he was going to testify about the alcohol. He's a motorcycle expert, accident expert, and he was going to testify that even the smallest amounts of alcohol can impair a motorcycle driver's ability to operate the vehicle safely. And I believe it was Mr. Draleaus, one of the plaintiffs, admitted that as well.
There was originally a preliminary decision by the trial judge that he didn't think he was going to let it in unless there was some kind of proof of impairment, correct?
Yes, physical or visual, like bloodshot eyes, inability to walk a straight line, slurring, and that kind of thing. And I put that in the brief because the trial judge at the trial pretty much said, I'm going to stick with that. But to me, that's an abuse of discretion when you look at all the case law that allows evidence in without any of those kinds of things. Simply that someone had been drinking that evening, simply that someone had smelled of alcohol. Now, those are very minor, and maybe they wouldn't have a huge impact on the jury, but we have much more than that now. And it's very clear from the case law in the brief and the State versus Nordstrom case that I just mentioned that in order to be admissible, alcohol evidence or drug evidence, we're dealing with alcohol evidence here, does not have to be blood percentage from a blood test. And that's essentially the secondary ruling that the court made here. He said, not only do I want to see slurring or physical evidence of intoxication, but I would have liked to see an expert doing an extrapolated analysis of 0 in the blood at 4 a.m. versus how much might have been in the blood earlier. The law simply does not require that degree, and that's what the State versus Nordstrom case, I think, stands for, is that these go to the weight of the evidence. They don't go to the admissibility.
I know you're into your rebuttal time, but I would like you to address that last issue, which is the failure of the motorcycle driver to have the ability to carry a passenger on his...
Yes. Now, certainly causation here is the big argument. The Bracken versus Bowles case does say that violation of traffic type statutes doesn't come in if there's no causation. But what we have here is it's not even driving a car without an adult in the back seat with the 16-year-old driver, which was Bracken versus Bowles. We have admitted evidence. I believe Mr. Draleaus admitted that the motorcycles operate differently with a passenger. And we also have the evidence that these gentlemen were speeding. Some said they were going 50, others said they were going 100 miles an hour. Some of the witnesses said they were going in between the cars at a high rate of speed. And that kind of testimony, which was let in, coupled with the evidence that having a passenger on the back can affect the driver's ability to operate the motorcycle adequately and non-negligently, it would go to causation, and therefore we believe that should have come in as well.
There was a case that was written by Judge Beth Bloom as a visiting judge, and in that case, the defense had admitted liability, so the judge kept out the fact that the defendant was unlicensed. And the case, one of the holdings of the case was that the case ruled that the failure to be licensed should have come into evidence because it related to the evidence of comparative negligence, which is, because Florida's a blameworthiness state.
Was that
Did
the
you
Lenhart
locate-
case?
I don't remember the name
I think
of
it's
the case.
Lenhart, and we did cite it.
So, okay, so that...
Yeah, I don't know that I
doesn't
cited it for that proposition, but I certainly cited it for the proposition that everything comes in, even if there's liability is admitted.
But wasn't comparative negligence an issue in the case?
Yes, that's
And
the
so
only issue.
wouldn't it also come in for
Yes.
comparative negligence as well?
Right.
Under that particular...
Absolutely, thank you, Your Honor. That is our position, that the comparative negligence of both Vincent and Draleaus. She's the one that got on the motorcycle with him, and one of the pieces of evidence that we wanted to bring in, which was not allowed, was that a few weeks earlier, a police officer had stopped them and told her to get off because she's not supposed to be on the back of that motorcycle.
Let me ask you this, though, along those lines. This I think is a pretty interesting issue. I mean, the fact of the matter is, though, that the reason why this person did not have, as I recall from my traffic court days, a motorcycle endorsement was because he didn't take the test. So how do we then say, okay, you didn't take the test, and therefore you must have been, that's probative as to whether or not you were negligent when you were driving your motorcycle?
I don't think it proves it, certainly, but I think it's a piece of evidence that, as I said, it's not, you can't look at it in a vacuum. And when the jury heard about the weaving in and out and the admission that a motorcycle operates differently with a passenger on the back, it's not that he didn't take the test, it's that he wasn't supposed to have her on the back, and not because he couldn't take the test. I mean, that's the real reason, but the negligence, if you will, reason is that the motorcycle operates differently, and he wasn't supposed to do that. So my answer is it would be a question for the jury. Thank you.
Thanks.
Good morning. Bard Rockenbach on behalf of the plaintiffs. First, on Judge Gross, you mentioned the Lenhart versus Pesora case. Just because, I mean, if we have a rule where the jury gets to hear all the evidence so they can compare it, that doesn't mean that that admissibility is out the window. Evidence, in order for the jury to hear it, has to be admissible. And in order to be admissible, there has to be some correlation. It has to have the tendency to prove that the fact in question and be sufficiently reliable.
What if the evidence were that the person driving the motorcycle had no driver's license?
That wouldn't matter. That's Bracken versus Bowles. Yeah, so no driver's license doesn't mean you're a bad driver. So here we have Mr. Regal, I guess it is, who didn't take the test to get the passenger part of his license. That doesn't mean he doesn't know how to drive with a passenger. He's been riding a motorcycle for how many years without an accident, without hurting anybody? There's no evidence here, and this will be a theme for the defendant's case, is there's no evidence connecting this alleged piece of wrongdoing on behalf of one of the plaintiffs to the actual accident. They just, in the entire defense, it was, we're going to throw some questions out there, call it comparative negligence, have no basis for admissibility, and then ask the jury to speculate. That describes perfectly the alcohol information. I'd call it evidence, except I don't think it was relevant, so it's not really evidence.
But wasn't the original decision about waiting to decide whether it could come in if there was a proffer of proof that someone's impaired, made at a time when only Vincent was the plaintiff? And
I believe it was just one, and then they consolidated them.
Right. So if that were true, why wouldn't the trial judge at the time of the trial reconsidered it, since that decision was made when everything was in a different posture?
There's two ways to look at that. Number one is the trial judge said, well, I'm not going to change the ruling from the previous trial judge. And then they went on to have a hearing that lasted, it looked like a half hour, and then he read additional information and cases, and then decided not to change the ruling from the previous trial judge. So it wasn't that he just said, hey, no discussion, stop talking, we're just going to go ahead with what was done before. There's significant discussion about this. Ms. Tutt said that there's all these cases out there that say you have to admit evidence of, even if you're just a little bit drinking and all this, just a little bit of alcohol. There is none of that. There's no case cited that says that the trial judge has to admit evidence that someone had a cocktail 6 hours before the accident or 12 hours before the accident. What there is Livingston versus Smalley. And Livingston versus Smalley says that in that case, the trial judge allowed evidence that there was a smell of alcohol from the plaintiff because it was part of comparative negligence. There was also other evidence of comparative negligence, and the The trial court denied the motion for directed verdict, so that's the first red flag on that case, denied the motion for a directed verdict on comparative negligence. And on appeal, the court affirmed that because there was plenty of evidence of comparative negligence. The plaintiff was driving the vehicle, a disabled vehicle without emergency flashers, was driving the vehicle improperly, and smelled of alcohol. And so they said the trial judge was in the correct, applied the law correctly on a motion for directed verdict, which requires the court to assume all the evidence in the light in favor of the non-movement.
But here you have, I don't have all the names straight, but the driver of the motor vehicle, I think it's Draleaus, by himself. And you've got...
Yes, that's Draleaus.
That's right.
Yeah.
And you've got a witness that smells alcohol in his breath, who's an independent...
Not his breath. No, just on him. That was a police officer. He said, I couldn't say the breath, it's just coming from him somewhere.
No, but Morales, the witness that was helping...
That was, I think, she was talking to Mrs. Vincent.
Right, she was
Right.
trying to help her, but she smelled alcohol on
Right.
him. And there was, both drivers talked about that they had had one drink or two drinks hours before. And then you've got the witness whose testimony doesn't come in...
Willette?
No, the one about the accident. But she also says they were weaving in and out. So there's if you add all that together, then you have something more like what you were describing.
All right. Now, if we're going to assume that every motorcycle driver who is weaving in and out of traffic is drunk, that means they're all drunk. Every single motorcyclist weaves around in traffic. They drive in between cars. So taking that's that ipso facto, we're just going to make it up and bootstrap it and say, well, I saw a motorcyclist driving between two cars. I can pull him over now. I have probable cause as a police officer
No, I'm
to
adding
pull
it
him
all
over.
together. I'm not looking at it in isolation, kind of like the totality of the circumstances. You've got a independent eyewitness that smells alcohol in his breath. You've got another independent witness unrelated to this initial accident that talks about the person driving kind of erratically and very fast. Why wouldn't that be something that the jury should consider?
Well, because of the burden of proof. We have a witness that says, I smell alcohol. Well, okay, great. Is it coming from the clothing or the breath? He couldn't say. So we have that problem. We have Morales saying that she talked to Miss Vincent, and Vincent had some alcohol in her breath. But you read their expert Willette's deposition, he said that the sum total of her alcohol consumption was part of one beer. Now,
Yeah, but she was a passenger.
She was a passenger, right. Mr. Lurvy, but she's still a plaintiff. And then they're trying to say that, you got on the back of a motorcycle with somebody you knew didn't have a passenger license, so therefore you're drunk. Because nobody does that unless they're drunk.
Well, should the ruling be different as to each of the different parties based on their circumstance? Because, all right, I give you that the passenger, that is just as you described, but then you've got the two drivers of the motorcycles that had at least one drink or two drinks or maybe more, and one smelled of alcohol.
Mr. Lurvy's the defense counsel here. He told the judge, I will never be able to tell you how much alcohol anybody had. The expert witness they wanted to put on said, I have no idea whether anybody was impaired. The testimony they proffered was to have Mr. Willette come in and tell the jury that any amount of alcohol, we have no idea how much alcohol these people had in their bloodstreams, but any amount of alcohol will make someone cause someone to have a problem driving a motorcycle. So that means that one molecule of alcohol in this man's opinion is enough to make a motorcyclist change the way he drives the vehicle? No, there has to be a point where they have carried their burden of proof of causation on the comparative negligence. They have to come forward with evidence to say that more likely than not, the alcohol in this person's bloodstream caused this person to behave in a negligent manner and cause their own injuries. But there was none of that, ever. This entire defense was, we're going to take whatever we can find, throw it in, say alcohol a lot. And if you read Mr. Lurvy's comments in that argument in the trial court, you can just hear the closing statement about how they were drunk, they're weaving in and out of traffic. How about the defendant, Mr. Stewart? He was racing with them he must be drunk too, because he was revving his engine and racing and weaving in and out of traffic along with them. So he must have been drunk, even though there's no evidence that he had any alcohol.
Well, what do you, let me ask you this though, Mr. Robert, what do you do when you have an expert, I guess proffered, that says, unlike motor vehicles, with motorcycles, even a slight amount of alcohol lends itself to the suggestion that the person could be impaired. And impaired, of course, I mean, is a wide range, but nonetheless impaired. So why doesn't that, as really to follow up on what Judge May said, why doesn't that really form the linchpin that just trips it to let it come in and let the jury do with it what they want?
Well, which would be to speculate, because they would have to speculate as to how much is in there, how much impairment, how much alcohol is in this person's bloodstream. And they could say, they could make it up. We could have a jury in the back, right, saying in the deliberations, just throwing out numbers. Well, I think he had 12 drinks and he was lying. No, I don't think he had any. And they could just go on forever and speculate about what impairment level he was, if at all, and then say, oh yeah, because he was this impairment. Now that we've decided this without any evidence, now we're going to say that he must have had this amount of negligence related to alcohol impairment that there's no evidence of.
I thought Regal did admit, though, that he'd had a couple of drinks earlier before, and
Yes.
Apparently it also looks like the reason the judge ultimately made the decision is that when they did the blood alcohol test at 4 o'clock in the morning, the accident having happened at like 11:30, there was no alcohol. So, because he says, that's the kicker for me.
Yeah. What the defendant should have done is had an expert do the analysis both ways. One is a regression analysis, go from the zero, which would be impossible to do, I guess, and say, okay, we go back and see what alcohol he would have had. Okay, that doesn't work because it's logically impossible to go from a zero backwards. Okay, let's go from what alcohol we can prove and bring that forward. And they didn't do either one of those things. Now, the reason they didn't do it, I will tell you, I believe, is that because if you take Mr. Regal's testimony that he had 2 cocktails between 7:30 and 10:30, you burn off a cocktail once an hour. So if he had 2, one at 7:30, one at 8:30, they're both gone by 9:30.
But if he has
both are
one
gone.
at 10:30 and he gets in an accident at 11:30.
Right. So why isn't there evidence of when he had it? Why didn't they have an expert in here? This is a comparative negligence defense. The defendant has a burden of proving the comparative negligence defense.
But they can't prove it if they don't let the witnesses come in and testify. Let me go back to the...
Oh, wait. No, that deserves... Please, may I respond to that?
Okay.
Because, if the witnesses can't testify because they have no evidence, it's just coming in and speculating. The evidence they're complaining about not putting in is an expert who says, I don't know how much alcohol they had, I don't know if they were impaired, but if they were, any level of impairment matters, even 1 molecule.
But then follow up with that, Officer Knowles explaining that he smelled a strong smell on Draleaus' person. I know it, not his breath, he didn't say, but on his person, and Draleaus admitted that he had been drinking. So why, in and of itself, why wouldn't that one issue? Officer smells it, I don't know if it's on his shirt, I don't know if he spilled it on his sweatshirt, I don't know if it was on his breath, and he admitted that he had been drinking. Why wouldn't that, again, come in for the jury to sort out? I know you're, obviously, from your perspective, because, Judge, they're going to start speculating all over the place about, really, was it on his shirt? Was it on his breath? Was it on his hair? Did somebody pour a drink over his face? Whatever that is, why, though, doesn't that tip the probative scale here to at least let the jury decide on that?
Yeah, because the analysis you're using is the probative prejudice analysis.
Right.
But this has to do with a causation. It's a comparative negligence defense. They have an obligation, a duty to prove the defense in the same way that we would have, as a plaintiff, have a burden of proving our claim.
Right.
So they can't just say, well, this evidence comes in because it is, it's not as prejudicial as all that, and he says he had cocktail, but we can't prove that there's any causation between him having 2 drinks at 8:30 and 9:30 and that the cause of this accident.
Can we go... I'm sorry.
No, go ahead, Judge, I'm sorry.
Can we go back to the accident report?
I was just going to get, I'm running out of time.
Stewart, I think Stewart is the name.
This is an interesting analysis, but you have a question, right?
Well, it might, because why doesn't Mactivia versus Schrag compel the fact that this woman was in a different accident and she wasn't in the situation as a driver, owner, or occupant of the motorcycles or the car that was allegedly involved, why wouldn't it have come in? I don't-
Because that person was a witness, and here, that's clearly a witness. The person had no, McTeviot versus Strag, the person we're talking about was just a bystander, happened to be there and following along in traffic
But
and saw it.
arguably, you could say that Stewart was, because she wasn't there when that first accident happened, even though that accident ultimately caused her to have a second accident, and she's
Right.
the one that has a lot to say.
Here's what I want to point out, and this is not something that is easily understood, so I'm going to take my time in however I can manage to do that. What the argument here has been is that we're going to take, there are two different versions of the accident if you
Right.
look at her testimony.
Right.
Just her, and not her testimony. Her testimony is this. What we have is the police officer saying what she told
said.
them at the scene. Now, if you take the police officer's comments of what she said, she is right there at the scene and she sees the two motorcycles collide and has to avoid them. Now, that makes her part of the accident, because when the police officer says, well, you crashed into the BMW over, actually it's to the left, you crashed into the BMW to the left, why'd you do that? And she'd say, well, I veered left. And they say, well, why'd you veer left? Now, if she said that, well, it's none of your business, officer, now that would be a violation of her obligation to tell the officer what happened in order to, because she has an obligation to report. And Judge Gross, you talked about in the beginning of this, was she under any risk of prosecution? That's not the question. The question is, did she have an obligation to just tell the officer what's going on? Most people can't even think about whether they have a risk of prosecution. It's just, do you have a duty to report what's going on? So we get to the scene in version 1 where she's so close that this all happens and she has to quickly go to the left and she hits a BMW. It would be a violation of law for her to tell the officer, well, I veered left. Why'd you veer left? I'm not telling the officer, it's none of your business. End of story. That's wrong. Then we go to version 2, which is the deposition. And there she says, I can't even see the accident. I'm behind a big truck. Now, if you look...
Now she's probably being sued by the BMW driver.
Right. Now, if you look at the, it's in the record, the accident report for her accident has her right behind this big black truck, and she can't see squat. So they go off, and the accident report shows them both going off together and then getting into an accident.
So that they don't hit the poor people that are already in the accident.
Right. So what the defense has done is taken the version of 2, where she's not really involved in the accident and can't see it, and she's a witness, kind of, but then says, and then we take that rule and say now she's not really part of this accident in version 1, and we have to let her come in and testify. And what she's really going to testify to is nothing, because she didn't see it. We have a police officer who's going to tell the jury what he remembers her saying.
What if she hadn't hit anybody? What if she hadn't been in another accident? What if she had been able to avoid the motorcycles, the people, and the BMW?
If she hadn't hit anybody,
would she still be then in the same
then
place?
she'd just be a witness.
She'd be like
She'd be
McTeviot.
McTeviot versus Schrag, right. But because the police officer comes up to her and says, ma'am, what happened in the crash? He doesn't say her crash versus their crash. He just says what happened in the crash. Now, she has a legal obligation to tell the officer what happened in the crash. And the crash necessarily involves, how did you get there? What happened to make it happen? You can't just tell the officer, what happened in the crash. Well, we collided. End of story. They have to explain what happened.
Does it make a difference as to which liability issue you're talking about? I mean, if let's say that the BMW did sue her, maybe they did, and then I would agree with you, because whatever she said also has to do with her getting in the accident. But she has no liability and no responsibility for that initial accident. So why should her statements be excluded?
Because the officer asked her what happened in the crash. And she has an obligation to tell. Well, if this is really her talking, these two motorcycles collided, I swerved left, and then collided with the BMW. So she's doing her legal duty. And it doesn't matter. The question is not whether she's going to be prosecuted for what happened there. That's why the legislature had to put the provision in the statute, because of the Fifth Amendment rights. But it's only that you haven't, they created a duty for a person to report the facts of their crash. And her crash is, I veered left because these two motorcycles collided.
It's an interesting case.
The hardest part is just remembering who's who.
I'll totally agree with you on that one.
You actually have an extra 3 on addition to that one
Okay.
to make
All right,
it,
thank
to
you.
even it out.
Dealing with this last issue first, while I respect counsel's attempt to argue the two versions and where she was in the one version and where she was in the second, well, those are jury arguments. You know, those don't go to the admissibility issue that we're here about. And I think the important point also
But doesn't
is
the
that...
judge have to make a preliminary finding as to whether the accident report privilege applies? I mean, so,
Right.
and so
Well,
he's got a lot of latitude
judge-
in making that preliminary finding.
Well, I don't think so. I do think the standard of review is de novo. That's my position. The Sotelaro case says that straight on. And all of this wasn't even argued to the judge, but the important point is the judge thought because she hit another car while trying to avoid this accident, it was one continuous accident. And that's what the judge ruled, and I think as a matter of law, that is wrong because there were two accidents, and I think just factually, I might point out that the police officer who talked to her...
It was the second officer, right? It was
Yes.
not the first one.
And he, you know, I get confused on that as well, Judge, but only one officer spoke with her. But it was clearly the one that was investigating the motorcycle accident. He said he didn't even know she was involved in her own accident. So if you look at her testimony, it's entirely consistent with that. It's about pages 45 to 50 of the supplemental record. When she was asked, what did you talk to the police officer about? And she tells about how she explained what she saw, the crash. She only was talking about the motorcycle accident. So there's no real intermix when it comes to what she thought she was talking about and who she was talking to.
Okay, let me go back to the question I asked you earlier, which is how would this have come in either as impeachment or substantive evidence? Since the plaintiff goes first, the judge is going to rule that this is coming in. My guess is that the plaintiff's going to put in the deposition testimony where she says, I didn't see anything. So now you're going to try and bring this other piece in to impeach her, saying, well, you told the officer this. So then does it come in as substantive evidence or only as a prior inconsistent statement, which doesn't really do you much good if it's not substantive?
I think it is substantive. I think mechanically, because it's a deposition that the plaintiff is putting on, I think, I guess it would be up to the judge to let us read impeachment testimony at that point.
Was she able to have testified in person or no?
I'm not sure why her deposition was used. I just don't know the answer to that. I mean, she was local at the time, but this accident happened a long time ago. In fact, I was checking earlier whether our expert's testimony, whether there was any Daubert challenge to him. This was in '09 when all of this was originally happening. So the only argument initially that they had to our expert was that he wasn't announced in time and he didn't have all the facts. Well, ultimately the judge kept him out just because the judge is keeping out all of the evidence of alcohol. But as I said, and as very clearly in my brief, there is not just one little piece of alcohol evidence here. There's a lot. I mean, there's probably 10 separate items of evidence. And it's just not required for us to prove what percentage these people had in their blood. It's just not. It's for the jury.
What, any weight do you give the fact that the original decision was made when only the lady on the back of the motorcycle had her suit in front of the court?
I think that if there was a ruling that, as a matter of law, the next judge was bound by that, I think it would make a difference because you can't impose that ruling on the other two plaintiffs. However, I will admit, as counsel stated, that the judge didn't just arrive at trial and say, "Matt, that's it, I'm going with the original judge." He did allow additional evidence on it, so I don't think I would go down that route. But for all three reasons.
Were they all tried together? I mean, they were all tried together, right?
Yes, after those initial in limine hearings, they were consolidated for trial, and they were all tried together. All right, thank you. We would request a reversal on all 3 points. Thank you.
Okay, so hopefully, you need to take a break, or we okay? All right, hopefully